Today, I'm going to be speaking with Spencer Headworth, who's assistant professor of sociology at Purdue University, affiliated scholar of the American Bar Foundation, and also author of the book Policing Welfare: Punitive Adversarialism in Public Assistance. It's great to have you on. I really appreciate your time.
Thanks for having me. It's good to be here.
So, I think maybe to get us into this conversation, oftentimes in popular culture, people will point to the Ronald Reagan stories about welfare queens as really raising the level of suspicion around welfare programs and so-called free riders. How far back can we trace that suspicion about people receiving benefits they don't really deserve and this type of idea?
Sure. So it goes back about as far as organized poverty relief programs go back. So you can look at English poor law in the 15th century, in the 1400s in England, and in those very early versions of assistance programs, there were provisions for, inspectors basically to check up on people and see if they were drinking or gambling with the assistance that they were getting from the state. And in the United States, again, it tracks back to the kind of earliest versions of public assistance programs that were out there. And in the 20th century, when we get food stamps, the predecessor to SNAP, the kind of earliest food stamp provisions included checking on people to see if they were violating rules. And it's a long history that's intertwined. There really is almost no historical period where welfare programs did not include some kind of suspicion, checking, evaluation types of mechanisms. That said, it certainly does ramp up in the Reagan administration in the United States as a politically and popularly salient issue, and a period when we get several key legal changes.
So, if a certain program has requirements in order to qualify, it seems intuitive that you would have some mechanism for policing that and ensuring that the people that are getting the benefits actually qualify. Now, in some theoretical sense, if one eliminated all of this bureaucracy for policing, there's some cost to that bureaucracy. In theory, it might actually, in the net, cost less not to worry about the so-called free riders and eliminate the cost of the bureaucracy. Has that been studied with any particular programs?
So economists have looked into this at least to some degree with regard to like a UBI type of system, right? A universal basic income. The idea of taking a means tested program like SNAP, like TANF that we have now, and completely eliminating the expenses associated with the policing mechanisms, it's really hard to tell. You can do some things, some very basic, back of the napkin, how much are we recovering per investigation type of math, but that does not take account for whatever deterrent effect the existence of fraud investigation has. The kind of broader symbolic components of the system that have an influence on people's behavior, which there is some influence, but it's really hard to determine how. It's the kind of counterfactual where we don't have these programs, we don't have data really, right? It's tough to say. And for the book, the primary data are interviews with people who work in fraud investigation, investigators and data analysts and managers of these units and so forth. And they, perhaps unsurprisingly, given it's their job, but they think that deterrent effect, which is hard to measure, is really substantial. So it's hard to say.
In policing by law enforcement, we have many examples of how a law or a statute can just kind of be written agnostically on paper, but can be applied in discriminatory ways or selectively. Can you talk a little bit about when it comes to policing of welfare programs? Does the same thing apply? And if so, how do we see kind of the discriminative application of some of these programs or of policing mechanisms, rather?
So there are ways that these programs, some of the ways that these programs function do have some implications, I think, for inequities in who's investigated, who's potentially charged with welfare fraud, who has these charges substantiated against them. I will note that nearly all of the people that I spoke to were adamant that they do not discriminate on the basis of race, that
Mm-hmm.
they, have no feelings about that one way or the other. One of the basic facts here is that they mostly investigate women because women are disproportionately participants in the program, right? So there's that difference.
I guess the question there would be, are they investigated at a greater rate than their level of participation?
They don't keep statistics on the characteristics of the people that they investigate, or at
Okay.
least they told me that they don't.
Okay.
So I can't say that for sure. I can say that, for example, being a person with children as opposed to a person without children has at least some effect on increasing your likelihood of becoming the subject of a serious investigation. So the one of the basic mechanisms here is they're trying to figure out which cases are most promising. So they have more potential investigations than they can pursue, so they choose which ones to go after.
Right.
And one of the main things that they're looking for is a higher dollar value. So if you're the head of a household with children, you're probably getting a higher dollar value in benefits than if you're not. So that's an example of just kind of a mathematical risk factor. Another thing that's going on here is the cases that are most promising to investigate are cases with more evidentiary availability, right? So if you can get more information about a person, you're more likely to spend more time on that investigation to make it a priority because you can get more access to evidence that you can use to substantiate your charges. So that means if you are, quote unquote, on paper in various ways already with government agencies, whether that be criminal justice agencies, agencies of the welfare state, whatever it is, if you have kids in school, all of these are potential sources of information that welfare fraud investigators can draw upon to figure out how much money you make, who lives in your house, these kinds of things. So being more recorded by the state has this sort of implication of also making you potentially more interesting as someone to investigate because this evidence is out there in ways it might not be for someone who's less recorded with the state.
When we talk about fraud, people, oftentimes the application processes for these programs are not particularly simple. And there's, it seems to me, at least in intent, a big difference between fraud and errors made during the application process. Can you talk a little bit about whether mistakes and errors or information that has since changed are considered fraud under this general umbrella?
First I would flag the person whose research is probably the best on this is Karen Gustafson, who wrote a book called Cheating Welfare. That's one of the inspirations for this book that came out a few years ago with NYU Press. And, she focuses on clients. And so she delves pretty deeply into this question of intent and the construction of intent and when is a mistake just a mistake. One thing that I can say for sure from my evidence and comparing it with previous work like Karen's that looks at the client side is that the investigators are much more likely to see things as intentional and present them as intentional than our clients, right? And that is in part due to the structural factors pertaining here. So they are the individual investigators and the broader units of which they are parts are incentivized to get intentional program violation charges, intentional fraud charges. Those are the sort of most rewarding for them professionally. They also garner financial rewards for the state from the federal government when you can substantiate these types of charges. So there are things that I think are borderline that get constructed as intentional. And the broad the sort of baseline understanding here is that if you provide a piece of information to the agency and sign your application form saying that everything that you've sworn to here is accurate and up to date, and then later they find evidence, whether it's from the Department of Labor, the Department of Motor Vehicles, or a privately maintained database of some kind, wherever they get it, if they find that evidence that contradicts whatever you put on your signed statement, that is generally considered probative proof of intentional fraud.
And What is the process for adjudicating something like that?
So in 1976, the U.S. Supreme Court ruled in Goldberg versus Kelly that welfare benefits are a form of property, and that therefore participants in the program are entitled to some version of due process before benefits can be terminated. So the way that that works when you're accused of an intentional program violation is in a setting that's called an administrative hearing, administrative disqualification hearing, perhaps, that is overseen by an administrative hearing officer that is the equivalent of a judge. And that's where the client gets an opportunity to come in and potentially argue against whatever allegations are being made, present their own evidence if they have evidence that contradicts the evidence that the welfare fraud investigator gathered. And then the administrative hearing officer makes a determination of whether the state has met their burden of proof in establishing, clear and convincing evidence of an intentional program violation. So that's one of the things that welfare fraud investigators have to learn how to navigate and negotiate is how to work in these settings, getting to know the particular hearing officers and what kind of standards they have. And it's, one sort of advantage that a fraud investigator has over a client is they're more familiar with the setting, right? They potentially know the hearing officer. They've been there before. They know, Ms. Jones likes this kind of evidence. Mr. Smith doesn't like this kind of evidence.
Right.
They're more inclined to do this or that. So that's the setting where these things are adjudicated. And one of the things that fraud investigators learn is how to navigate and negotiate in those spaces.
One of the things I wanted to talk a little bit about is just other systems in other countries that may overall be more efficient. And one could argue, part of it depends on your perspective, but one could argue that there's lots of inefficiencies in these systems. One could argue that the means testing itself is an inefficiency. One could argue that the methods for policing are inefficient. There's a lot of different approaches to that. But in terms of benefits and cost efficiency overall, what should we be aspiring to? What sort of examples in other countries are particularly well run?
So I'm not an expert on international welfare states, but I will say that there is, I think, a very strong case to be made for a universal basic income type of system where you remove all of this administrative overhead, all of this bureaucratic red tape, and create a much smoother flowing system without all of these hurdles and barriers and all of the associated costs and expenses. And so people who are experts in this area, at least to the extent that I've read them, generally associate a system like ours that focuses on means testing with the almost inherent or inescapable circumstance of rule enforcement being a big part of it, right? And this process of determining who's in and who's out being a costly endeavor. So in a system where you can eliminate those administrative expenses, you're saving that money. So I think that there's definitely a good case to be made for more of a universal system. I mean, something like we have now in the United States, but just based on age, right? For Social Security benefits and Medicare benefits.
In such a system, both when it comes to UBI and so-called free college, there's the criticism that you're also giving stuff to the very, very rich. Now, the very, very rich statistically are a small percentage of the economy, but by sort of definition. Is that something we should worry about or not?
Well, I mean, I won't tell people what to worry about or what to not worry about, but there is an inherent logic to a means-tested system, right? It makes a lot of sense, I think, in an abstract world or just, on paper, that people in need should be the people that receive things. But it just gets very complicated when you come down to the process, okay, what is need, right? How are we going to calculate that? That's contentious in and of itself. And then, these administrative costs, I think, they're often not visible publicly, right, or not really prominent in the popular imagination. And again, there is this inherent logic to targeting aid to needy people, but where the rubber hits the road, it's a lot more complicated than just see who's needy, give it to them. Don't give it to someone who's quote unquote not.
Yeah, yeah, that's for sure. That's for sure. The book is Policing Welfare, Punitive Adversarialism in Public Assistance. We've been speaking with the book's author, Spencer Headworth, who's also assistant professor of sociology at Purdue University. So great having you on today and really appreciate your time.
Thanks, David. It was a pleasure.